Welcome, ladies and gentlemen. My name is Anil Changaroth. I'm RHTLaw Asia's co-head of the ESG practice and a partner at the dispute resolution practice here in Singapore. Welcome to this series. Those of you who have come to the series for the first time, a quick idea of what this is. This series involves our ASEAN Plus law firms. Right. So if you go and take a look at our website, you will notice that within ASEAN, we've got several law firms in several jurisdictions that we work together collectively. And so this is the first of our what is called the RHTLaw and ASEAN Plus series, right? And the first of this series is about construction law, right? So last week, what we had was that Singapore, both myself and my colleague Shafiq Lim, had presented on two of the latest cases that we thought were relevant, right? And we spoke for about 25 minutes to 30 minutes. And then we had views from our regional partners in respect of our two cases, all right? So we have from Indonesia, Adi. Just put your hand up and say hello. We'll come back to you again. All right.
Hi, everyone.
And, from Korea, we have Tim and Jason. All right.
Hi.
Okay. And then we have Hung from Vietnam.
Hello, everyone.
Right. And from Cambodia, we have Vana and Vishal. All right.
Hi, good afternoon.
Good
Okay.
afternoon.
So now today's session is going to be essentially from Korea. While we last week took the issues about two cases, they are taking down the path of issues in relation to legislation. So really exciting. I'm going to pass it on to them. And when they speak, I'd like to just have them each say a little bit about themselves as well before they start the presentation. And so they will take about half an hour or so, and then we will go around the circle with Indonesia first, Vietnam, Cambodia, and Singapore making comments on what Tim and Jason are going to present. And then we'll open up, if time permits, we'll open up to everybody who may have questions raised. Thank you so much. Over to Tim.
Hi, thank you, Anil. Thank you for that introduction. And a warm welcome to everyone this afternoon. Welcome from Korea. It's a beautiful summer day, not too hot, so it's a perfect time for this opportunity. To give you a quick background about myself, my name is Tim. I have been with our firm in Korea, Derrick and Arju, for 10 years, and I'm part of the international transactions team. So obviously that includes a lot of M&A work, which includes infrastructure, both on the front end and back end. So a lot of the upfront side of work, advisory, etc., but also, as you are well aware, the backside of the dispute side, which inevitably from the construction side ends up in a dispute. Also, a warm welcome to our Asian partners. It's always fantastic to see you online. I will hand over to Jason later, and he can do his introduction then. So essentially, on the topic that we've decided to cover for our Asian Plus region, for the infrastructure and construction law, the mid-year review, we've decided to focus on an area which, for those of you that are involved in construction, may or may not know in Korea, the SAPA, the Serious Accidents Protection Act. Now, although this isn't exclusively something that's only applicable to construction, by the very nature of the construction and infrastructure sector, this legislation is a key legislation in terms of its applicability and influence in those sectors. So what we've decided to do is take a look at a brief introduction to the legislation if you're not familiar with that. And then we focused on two of the most recent cases. And this is important because they're the first cases that have come out from the court's decision in terms of how the courts and the prosecution look at issues where there have been breaches of the SAPA regulation. So what I'll do, we'll do a quick introduction, then we'll go through the two cases and a quick summary in terms of compliance. So essentially, to give you background to the legislation, what is SAPA? So The name itself is very particular. It's not the Prevention Act. It's not a Protection Act. It's very clear in that it's a punishment act. And I think that's very important because through this act, it holds CEOs of companies directly responsible for any industrial action or issues that have happened in terms of breaches of safety on work, etc. So the key point here is that the top management liability is the most important aspect of SAPA. The act itself was introduced in 2021. There was a 1-year, let's say, grace period, and it came into full operation in January 2022. Now, the reason why we're only raising and bringing up this issue now is because we've had the first cases that have popped up. So I guess for the last year, everyone's been sitting with bated breath to see how the police, how the prosecution office, and how the courts would interpret this new legislation and how they would apply that in terms of the sanctions that they've meted out. To give you a bit of background, prior to the SAPA, we had the Occupational Health and Safety Act, which was implemented, I think, as early as 1981. And that hasn't been amended or wasn't amended really much in that sort of space of 30, almost 40 years. But what was happening was that particularly the National Assembly indicated that existing Occupational Safety Act did not really properly provide for expected measures such as prevention of accidents, any follow-up and preventative measures that would have to be implemented, and also damage restoration from life-threatening accidents. So because they felt there was not much movement, and having a look at numbers to give you some idea, I think for construction site fatalities in 2020 in Korea, there were 39 among the top 100 construction companies. And at the same time, in terms of occupational accidents, I think there are around 850 odd. Half of those were from the construction industry. So the legislation decided to take an active role because under the Occupational Safety Act, the sort of mid-level managers, the sort of site managers were the only ones which were held responsible. But as you well know, unless the top management are put under under the firing line, not a huge amount of change is going to happen. So that was primarily why SAPA came into being. So if we move on to the next slide, expanding the scope, I think we've just touched on expanding the scope in terms of the top management. So for purposes of today, we'll refer to the RMO, basically meaning the responsible managing officer or ROO in terms of this. And that would be quite broad. It can be obviously CEOs, the chief safety officers. It holds accountable basically business owners, executives, public workers, corporate entities who are responsible for causing harm by breaching their duty to ensure compliance with health and safety. So I think that's the critical part in the expansion. So we had a much limited sort of ring-fenced responsibility to certain on-site parties under the Occupational Safety Act. That's now been expanded under SAPA to be much more encompassing, particularly from the top management's perspective. And I think that's a critical part. On the next slide, the enactment, as I mentioned, came into operation in 2021. There was a year sort of grace period before it was implemented and enforced. And it from next year, 2024, it'll now also be applicable to small business. So initially it was only open to more the big size conglomerates to be compliant. That's going to be increased now to even the smaller scale businesses. So that means it's pretty much going to be applicable to all companies unless you are a business with less than 5 people. But from a construction point of view, very unlikely that that's going to be then applicable to you. If we move on to what is a serious accident and how SAPA defines a serious accident on the next slide. Under the meaning of serious accidents, SAPA at least separated into two. So on the one hand, we have serious industrial accident. Essentially, that is any serious accident caused by a work-related structure, equipment, raw materials, gas, steam, dust, anything caused in the course of performing work or other duties. On the other hand, the other portion of the definition, which would be a serious public accident, which be any serious accident caused by a defect in design, manufacture, the installation, management of certain raw materials, product, public facilities, or public transportation. So those are the sort of the overall definition of what a serious accident would be. And if we look on the table, you'll see it's divided into also the damage caused, let's put it for an easy way, to individuals. So under a serious accident, industrial accident, if there's a death of one person or more, obviously, alternatively, an injury to two or more persons, which require more than 6 months of medical treatment, or an occupational disease of 3 or more persons within a calendar year. Very similarly, on the public accident side, it's a death of 1 or more persons. For injury, it's 10 or more people, which require more than 2 months of medical treatment, or a disease, which is 10 or more people from the same cause, which require more than 3 months of medical treatment. So the moment you surpass any of those minimum sort of standards, that's when the act will then become applicable and kick in terms of how they would enforce it. So if we look at the next slide, this will now be the criminal element in terms of the sanctions which are applicable under the 2 different definitions. So if you look on the left-hand column, you'll see we've broken it down into the serious industry and serious public accidents. So in terms of the first portion, that could be an imprisonment. So if you've got a death from a serious industry accident, an imprisonment for 1 year, and or a fine, criminal fine of up to 1 billion Korean won. So that's roughly, I guess, 800,000 USD. For the corporation itself, you'll also look at a criminal fine of up to 5 billion. So that's probably 4.5 million USD. For an injury, for 2 or more persons, or in the case of the serious accident for 10 or plus persons, it's either imprisonment of up to 7 years, which is quite substantial, or a criminal fine of 100 million, which is, I guess, about 80,000 USD. And that also includes the both for serious accident or the industry. Then from a regulatory perspective, there's a requirement for up to 20 hours of compulsory training, and administrative fines are applicable if this doesn't happen. I think you see that in general application, whether it's workplace harassment, sexual harassment type of trainings, these are becoming more and more common in terms of the compulsory aspect of that. Then a further aspect for punitive damages. So again, if there are actual damages from willful misconduct or gross negligence, the courts can also find up to a 5 times actual damages, which is can be quite substantial, particularly if you're looking at, for example, a death on a construction site. So that's quite substantial from that perspective. So in terms of the obligations that are applicable, there's quite a few of them, altogether 8 obligations. This table just sets out a very simplified bullet point perspective in terms of what's required. But essentially, I sort of break it down into the 4 main categories. So number 1, it would require at least securing measures to establish and implement a health and safety management system, which obviously then comprises a manpower aspect and also the relevant budgetary to prevent these accidents and disasters. A second leg would be securing a system to prevent recurrence of the accidents and disasters and to implement the relevant measures to prevent that. A third leg would be securing measures to implement an improvement and correction orders of a central or local government agency. And a fourth leg would be securing measures necessary to perform obligations under safety and health regulations. They are quite extensive in terms of the application. For example, if we look at establishing, for example, a monitor to establish a monitor for contingency plan, that would require, for example, preparing contingency measures such as suspension of work for serious accidents, development of relief measures, incident reporting systems, checking and monitoring systems, maybe on a quarterly basis or on a half-year basis. if we look further into management of hazardous and risk factors, and these are where you are particularly involved in industries or sectors or businesses which are very high risk in terms of managing chemicals, for example, or explosives, you'd have to establish very particular adequate work procedures for dealing with these and checking and monitoring these. Again, you have to monitor compliance with health and safety regulations very particularly to make sure that you're not missing out on any nuances that you aren't ordinarily used to. Taking measures to assign the relevant workforce and budget for those constraints, making sure that the relevant safety and health training has been provided and at least supplied to the staff on site. So I think from that perspective, it's very important. Another very important aspect from this is it's not only applicable to your direct company. So if you are a construction company and you have your subcontractors on site, you also have the duty to ensure that you are establishing the same requirements for them. So what it actually adds in is a whole new level of diligence on who you are using for subcontractors. So if they are the cause for the damage because they've breached certain regulations and they're on your site, your company and the head of the company will then be held responsible. So I think those are really critical elements, and has created quite an uproar in terms of, number one, foreign companies doing businesses in Korea. If suddenly your CEO can be held, liable, criminally liable, and that's a massive consideration to make. So it's very important to acknowledge that this exists. And I think we'll move on to Jason to go over the two cases that have just been sort of heard and sanctioned in Korea, to give you a bit of understanding as to how the courts are starting to look at these breaches, how the prosecution is starting to look at these breaches. So I think I'll hand over to Jason to sort of take you through those two cases, and then I'll wrap up at the end with just a short compliance section. Over to you, Jason.
Yeah, thank you, Tim. Make a quick introduction on myself. My name is Jason Park, and I'm a U.S. attorney licensed in the state of New York. I'm currently based in Korea and have been in the legal industry within the Korean market for the past 15 years or so. I'm currently with the international practice group at my law firm, Deruk and Aju, abbreviated as DR and Aju in short. Prior to joining the firm, I have been an in-house counsel for about 13 years with major construction companies in Korea, primarily supporting their overseas projects. And with that introduction, I'm going to now go back to our presentation. Hold on, let me share the screen again. So I'm going to go over the cases. There are two cases which I'm going to present to you, and after that, I'll pass the mic over to Tim again to wrap up our presentation. The first case is we call Unyu Partners. It's the name of the company that was held criminally liable. It came out this year, early this year, April 6th, actually. This the importance of this case is that this was the first case ever that came out on the enforcement of the Act SAPA. Here, the CEO of the company was sentenced to 1.5 years in prison with the stay of execution for 3 years. Now, the case summary here, this is just basic information on the court, and I've actually included the words in Korean, which you can use perhaps to look it up on the internet. And the company, this was actually a small company in the construction industry, and you will remember Tim mentioned that the act there was a grace period for about a year, and then this other grace period which applies. There's a 3-year retention period until the act actually applies. And let me just go back to that slide. You mentioned that the enforcement to start on small businesses, 50 employees. The act would apply, the enforcement of the act would actually commence next year, January of 2024. The reason I'm mentioning this is this company, Anu Partners, is actually of size with their permanent employees roughly around 40 employees, I believe. So according to the act itself, the company might not really, the act might not apply to this company, but then I'm going to show you a part of the act is that there's actually an exception for the construction businesses. And for the construction businesses, it's not really the number of employees. What's important for the construction business is they will look at the construction contract value. So this is actually the extract from the contract from of the Act SAPA, Article 1. It actually says the Act shall enter into force 1 year after the Act, the date of its promulgation, provided that a place business with fewer than 50 full-time employees. In cases of construction business, construction works with the construction cost of less than 5 billion won, which is about I'd say roughly about $5 million US, a little bit smaller than 5 million US dollars. But what I'm saying, the contract value for the project that we're involved in was actually 8.1 Korean won. So they belong to this exception. So the act was actually applicable to this company right now. Going back to the slide, going over this case summary again. A serious accident. What the serious accident was, there was one person who actually died from the accident. Worker of the contractor of Anu Partners fell, and he died at the construction site of a senior care hospital. And the final sentence was the CEO of this company, there was an imprisonment of 1.5 years with a stay of execution for 3 years. That's the case summary. And I'm going into the details of the cases. I'll give you the facts here. Defendant is a small construction company with about 40 employees, which engages in local small-scale construction projects. Contractor was engaged in construction project for the remodeling works in a local senior care hospital and had a subcontract with company B to perform certain steel works for the project. In May of the same year, an employee of the subcontractor fell from the 5th floor of the building while carrying a 94-kilogram rebar without wearing a safety harness, and resulted in his death. And the issue was there wasn't any prior safety inspection of the site had been done, and there also no safety measures have been taken, put in place to prevent the fall. The procedural history: defendants that are prosecuted, the contractor company, Anu Partners, and the CEO, the site manager, and all the relevant safety related personnel are also brought into the case, and also the contractor company and their subcontractor and all their responsible personnel as well. For the purpose of this seminar, our case will just focus on the contractor company's CEO as the main defendant. And when the case was ruled in April, the defendant decided not to take it to the appeal. So no appeal was made after the first instance ruling. The issues before the court: whether the defendant breached their obligations under SAPA, and whether the defendant's breach was actually a cause of the accident. And thirdly, whether the penalties for defendant's breach of both SAPA and OSHA should be aggregated or treated otherwise. The holding of the court, I mentioned this already, the CEO of Anu Partners had an 18 months imprisonment for violation of SAPA with a stay of execution for 3 years. And the site manager, there were other penalties for these other relevant people, but I think I can skip them. The focus of this case right now is with the top management. So turning to the case analysis, the evidence showed, the court held that the evidence showed there was a serious accident because there was death of one or more persons, and there was a breach of SAPA regulation. The breach was that the defendant failed to take appropriate safety measures, such as the duty to establish procedures, to identify and address risk factors, duty to establish standard criteria for evaluating safety and health managers, and so on. These are the specifically provided for in the Act SAPA, and court needed to prove that the breach of these regulations was a direct cause of the actual accident that took place. And the court did not really go too much into proving the causation, but they simply stated that because of the safety harnesses were not provided to the workers and bars were not provided to the workers, that is the direct, obviously it's the direct cause of the accident. And what that means, defendant's failure to comply with the SAPA, not providing these safety measures, that eventually led to the event safety tools not being provided, thus it's the direct cause of the accident. That's the case analysis. And the third issue that was covered in the case was on the issue of whether the crime that is constituting here, whether that should be a compound or complex crime, or it should be considered a composite crime. The difference between these two is that a composite crime is where each of the different specific acts of the defendant leading to two different violations. So eventually there are two different crimes. So the penalties, the resulting penalties will be added up, will be aggregated. But with a different category, which is compound complex crime, this is where a single act leading to two crimes, one's a violation, here in this case, one's a violation of SAPA, and also a violation that was found in the existing older legislation, which was OSHA. Here, the court actually stated the penalty for this for this particular case, that the penalties for the most serious crime will only be impressed. In this case, would be SAPA. So the penalties for OSHA have been ignored in this case. Next is implications, the takeaways of this case. Out of the prosecuted persons, the CEO, I mentioned earlier there were number of defendants. But out of the prosecuted person, CEO of Anu Partners, he received the most severe punishment due to his breach of SAPA obligations. This implies the violation of SAPA will result in a more severe criminal punishment than occupational negligence or breach of OSHA. And as I just mentioned, the concurrence SAPA and OSHA violations would likely lead to a compound complex crime situation that the penalties of the more severe punishment will apply. And the court, in their analysis, when they ordered imprisonment of the CEO, they actually mentions there are certain extenuating factors. They actually did consider whether the defendant made any settlement with the victim's family, and whether he made any promise to ensure that the company will take certain safety measures in the future, and whether the victim was negligent in any way. Maybe that could have contributed to the death of the person. So some of these are the factors that the court will actually look at when they will determine the final ruling of the case. The imprisonment ruling. This imprisonment ruling will become a guideline, standard for future similar cases. Critics actually say, when this case actually came out, the critics mentioned that Onyu Partners, the case is notable as it's the first SAPA case demonstrating a CEO can actually be held criminally liable. But the critics actually mentioned that the sentencing was too light because it did not result in an actual imprisonment of a person, because the imprisonment itself was actually suspended for 3 years. So there were some certain critics were mentioning that this was not really the right case. And then came the second case. This actually is only a matter of 20 days. I think the first case came out on April 6th, and the second case came just about 20 days afterwards. This case is notable because the CEO here was actually sentenced. The sentencing here resulted in an actual imprisonment. In other words, without a stay of execution. Here the company was a steel company, a medium-sized company in the steel manufacturing industry. Here, the accident, the description of the accident is that the worker died from the drop of a 1.2 ton heat-sinking plate on his leg. The CEO, as I mentioned, the actual imprisonment here of 1 year, and there was a criminal fine of 100 million Korean won. Turning to the facts, Hankuk Steel Mill, steel manufacturer, they outsource their repair work to a subcontractor, and an employee of this subcontractor was actually killed in a collision with the heat sink in the plant. Here, the differentiating fact from the previous case was that the representative director, is the Korean term for CEO. The CEO of this company, he had actually prior records. He had been repeatedly penalized for violating occupational duty to take safety measures on several occasions. He had actually been punished for a fatal accident during this 1 year period, grace period. So the act did not really apply to him at the time for the same act. Procedural history after the first instance case, the holding, the defendant filed an appeal. Unlike the first case, the defendant here actually filed an appeal, and the appellate court's ruling just came out just last month, not only about 2 weeks ago, I guess. And the first, basically upholding the first instance ruling. So the defendant is still guilty. the issues before the court, I think I'm going to skip over the first four because they're pretty much the same as in case one. The last issue, as I mentioned in while explaining the facts, the issue before the court would be whether the defendant's past records, there were multiple cases of violations, whether that should be of any consideration for the court in determining the sentencing of the defendant. The holding is a 1-year imprisonment without the suspension order. This other defendants, business owner of the subcontractor, had a 6 months imprisonment with a stay of execution for 2 years. There was a criminal fine applied to this company, Hankook Steel. Going over the case analysis, evidence showed there was a serious accident, meaning there was a death of one person, and the breach of SAPA, basically the same as the first case. And this last issue I mentioned that we are focused on is whether the defendant's past records shall be considered in determining a sentencing. Court answer was yes. The court mentioned, these are the exact words that the court actually mentioned. There have been multiple counts of violations over the course of many years within the same business organization, meaning there's a structural problem endangering the safety rights of the workers. And what this means, there are sufficient grounds for treating a more severe punishment. The key takeaways of this case is that this time the actual prison sentence was imposed. Like I mentioned, the main difference between the first case and this case is that in case 2, defendant had been repeatedly penalized for violating his occupational duty to maintain safety measures. Thus, he became subject to a more severe sentencing. There's a real term of imprisonment without a suspension of execution. Court actually also mentioned that some of the factors that they will look at in weighing their sentencing. Both of the courts, case 1 and case 2, they consider the extenuating factors such as the defendant's action following the accident, whether they actually admit the wrongdoing, or whether they are suggesting they will take remedial measures, and whether they actually have been taken to improve the worksite condition, whether the defendant actually attempted to settle with the victim's family, and whether the victim's family petitioned for mercy and so on, and they will also look at the industry practice and so on. So what I'm saying is there is not a single factor that will determine the sentencing, but there will be it will be a totality of circumstances. They will look at multiple factors. That's those are the 2 cases, and I think I'm going to hand over the mic to Tim to make a conclusion. Tim?
Thank you, Jason, for that very thorough breakdown. I'll wrap up in 1 minute. Time is ticking. So what we need to look at in terms of our clients and companies that are facing the SAPA issue, how do we prepare? How do we prevent ourselves from facing possible criminal sanctions? So, we have to look at, obviously, the SAPA regulations. We have to look at the government roadmap in terms of what their ideas are and how they may amend the SAPA going forward. And obviously then looking at criminal cases to see how the courts interpret it, how the prosecutors interpret it, what factors they look at in terms of making the decision. So from our perspective, we think that compliance is a very critical key. So what this essentially means is we need to verify and basically do full due diligence on all your subcontractors and contractors that you're working with, because we need to certify and verify that they are compliant, that they have the relevant processes and procedures in place to prevent these type of incidents. How we've actually gone about approaching that from our law firm's perspective, and I think we're the only firm in Korea that's come up with this idea, is to do certification along the process. So we've teamed up with the Korea Industrial Safety Association, KISA, to provide safety consulting and industrial, basically SAPA compliance certification. The certification itself is not a get out of jail card, but what it does do is adds layers into your defense. So if something did happen, because accidents do happen, at least you can say, these are the steps that we've taken. We've even got outside third-party consultants and risk management to take a look at our internal processes, our subcontractors, our contractors. So basically, we've done everything possible to ensure that nothing happens. So it's risk management at best, but that's the only other way that we can see at this stage to ensure compliance and to avoid any sort of criminal activity. So I think I'll wrap it up there and look forward to some of the input from the other ASEAN Plus members.
Thank you so much. I'm just going to try and change you. Let's see where we are, the participants. Okay. So thank you so much, Tim and Jason. And let me just highlight, where do I pin? Right. Okay, just a couple of quick points before we go to everybody else. I like the point that Tim, you said that it's not exclusive. I mean, the starting point is that it's not exclusive to the construction industry, but both of you spoke extensively on how it relates to the construction industry, because our series is really about construction industry, right? And you said that it was a punishment act, right? And that was quite critical. Jason, you went down the path and you explained the case law, and many of the cases all said suspended, right? We'll come back to that in Q&A later. But the last case that you then highlighted said where there was this particular gentleman, he didn't get a suspended sentence, he had a 1-year sentence, right? So I suppose to some extent the severity of the involvement and what they did and what they did not do played a part. And in wrapping up, Jason, Tim, you said, you got to look at regulations, got to look at a roadmap. And I like the point that both of you have said that you're actually involved with the industry on helping them move forward. And so that's something I think it might be very interesting for us to take away at the end of the day as well. All right, we go to Adi in Indonesia. Your views, please.
Yep, thanks, Anil. So maybe just a quick points from Indonesian perspective. We do have similar requirements on health and safety at work, but the problem with the Indonesian legislation is that it is still scattered around. So we do have some provisions under construction law which apply specifically to construction sector. We do have a certain provision also related to health and safety at work and at construction site provided in the Social Security and Insurance law. Most of the provision, I think, this unlike what is happening in Korea, I think most of the specific regulation refers to more of an administrative sanction rather than criminal liability. But in terms of the criminal liability, I think that will fall under our Indonesian criminal code, especially if it causes if there is a negligence, either negligence from the director or the project manager, which causes death or injury to the worker. And we do see some occasion I mean, if you come to Indonesia, you always see if there's a large scale construction site, you see that the kind of a banner saying that this construction project is insured by so all the workers in here are insured and compliant with the health and safety at work requirements, right? And I think failure by the company, by the contractor and the obligation is imposed to the contractor to enroll their workers in the mandatory social security insurance, and failure by the construction company to enroll their workers may also result in the I think it's a fine. The amount of which is not really substantial. It's only at like 50 million IDR, around 5,000 or 3,500 USD. But I think to some extent you can the director or project manager can still be held criminal liable, aside from the administrative sanction, if and to the extent that it can be proven that there have been negligence, they didn't do the necessary duty of care, which and that negligence is the main cause of the injury or death. I think yeah, the problem with Indonesia is that the law is still really scattered. We don't have one consolidated act, just like enacted recently in Korea. I think that's just a brief points on Indonesian law.
Thank you so much. So I think maybe the takeaway, a quick point or takeaway from this is that if your government and the construction industry is starting to look at safety and regulation, safety and health issues, you have guidance from Korea, what they have in place, and later when I speak about Singapore, you probably have guidance from there as well. So something to keep in mind moving forward. If you can engage the industry, that might be a very interesting point to take note of. We go now to Huang from Vietnam.
Hello. Actually, in Vietnam, we do have provisions on labor safeties and safety as constructions under the laws on occupational safety and hygiene. And for those who violate this law, they will be a sentence under the criminal code, which is monetary penalty up to 100 million Vietnam dollars, around $4,500 US dollars. Non-custody reform for up to 3 years, or imprisoners from 1 to 5 years, or 3 to 7 years, or maybe maximums at 12 years, depends on the extent of damage or how many people dies from the accidents at the construction site. And it's applied to all the people and do not have any specific provisions to the top managers. So it means that when the top managers violate the provision, the regulations on labor safety, they will be treated the same as other people. But however, for the top people, top manager, they can be prohibited from holding certain positions or practicing certain professions, or doing other jobs from 1 year to 5 years. So that's some provisions in terms of Vietnam law I would like to share. Thank you.
All right. Interesting. So two takeaways from your side is the fact that there are three takeaways. One, that there are regulations and legislation in place. Two is that usually it's a monetary imposition. It's money as opposed to jail time.
Yes, it depends on the extent of damage or how many people dies from the accident. So it's the courts will decide the penalty to the one who breached the law.
Yeah, and the third was the fact that the prohibition of holding certain positions. So that might be a very good way of making sure that people do comply. So thank you so much for that.
Yeah, thank you.
We go to Vishal in Cambodia.
Thank you. For the case of Cambodia, our new law on construction 2019 also has something to talk about this, and we goes in similar direction with South Korea. And of course, it's a bit different because our law put more weight on technical directors in the construction business company when it comes to this type of accident. And we can understand it because our law for technical director, even if they work in a company, they act independently based on their professional code of conduct and technical regulation. Mostly technical director are the licensed engineer and architect, so they have their own professional code of conduct to comply with. and they are the one who are in charge of technical issues in the construction. And also about this technical issue, our law on construction set out the technical obligations for the construction business company to comply. And in the case that the technical director does not comply with this obligation and such non-compliance causes accident which affect the health and safety of others, then they will be subject to criminal responsibility. So what are these type of compliance? We cannot go into detail here, but just to give you the pictures, the law on construction set forth that the construction business company need to comply with the decision of the competent authority, mostly from the Ministry of Land Management, Urbanization and Construction. They need to comply with the permits. They need to comply with the building technical regulation and other existing regulation and instruction, and of course, technical regulation on construction material, equipments, and products. So in the case that the technical director of the company, business construction company, they don't comply with this and cause those accidents, they will be subject to criminal responsibility. And if we ask how serious is the punishment, how serious is the crime, it's really depends on the seriousness of the accident itself. A bit different from South Korea, they have number of people injury, number of deaths to determine how serious the crime is. And if we look at the law in Cambodia, we can actually classify it into 3 levels. The first one is the injury or damage to other people's health. And this second one is the amputation of limbs or permanent disability. And the most serious case is causing death to others people. So based on this level, the court will have to decide the penalty, and the imprisonment from 1 year to 15 years. So it's quite serious in the case of death. And also the penalty also includes monetary penalty, criminal penalty in this case. And just one note before I end here is that just because the law put more weight on technical director, it doesn't mean that others are safe from this criminal responsibility. So those who commit the crime will be responsible for the crime, but who exactly will be responsible, we really need to look at it in a case-by-case basis. So thank you.
Right. Oh, so thank you so much for that. So a couple of things, 2 things. Well, it's one is the criminal responsibility and you have legislation. 2 is that the level and the decision on that includes the kind of injuries and damage, whether it's permanent disability and whether it's causing death. So you start to see that, it's all similar around the region. So if I could just then quickly, because I'll talk about Singapore. All right. So I'm just going to unpin you. Right. So I'm going to talk quickly about Singapore. Singapore has got this, what's called the Workplace Safety and Health Act 2006. All right. Okay. So in 2006, it came into force. It replaced the Factories Act. But amendments to that took place in 2008, essentially extending the protection of the Workplace Safety and Health Act to all kinds of workplaces and imposing new duties on principals in relation to the contractors, principals who undertake the duty to take necessary measures to ensure the contract and all that. So it kind of expanded the role similar to what Korea had indicated. The necessary, that means those people who have necessary expertise in carrying out the works and who are engaged contractors, whether you take adequate safety and health measures in respect of any machineries, equipment, plant, articles, and process used, or to be used by the contractor. So all of these are all covered in this new act. Okay. Now the significant changes to what the act did was this: it started to impose duties on many more persons beside the occupier. So before, when you had the Factories Act, it was just the occupier. But under the Workplace Safety and Health Act, that imposition was on far more people. And you'll consider the breach of any provisions resulting in only criminal liability. So this act really takes into account and deals with criminal liability. All right. Next, It provided far greater penalties in order to make sure they're deterrent. So, anything that's related to death resulting from a breach, failure to heed warning, degree of risk, extent of the dangers created, all of this would have been taken into consideration. But to assist companies, what the authorities also did was this: they provided a code of practice. So you have this workplace safety and health risk management, where it started to gain momentum in Singapore. More duties for holders are being recognized for the value and the benefit of risk assessment. So there's the thing about making sure whether or not you conduct proper risk assessment. And so if a company carries out activities and it shows that it's done proper risk assessment, then the liabilities imposed may be slightly less. There's also a code of practice that deals with chief executives and board of directors. It's called the Chief Executives and Board of Directors Workplace Safety and Health Duties, right? Also a code of practice. It launched in September 2022. It provides practical guidance on safety and health in the industry. So the outline is desired. The outcome is to make sure that organizations put in place proper systems. They make sure that the proper people who are responsible take charge of managing the workplace safety and health, including in terms of risk management. All right, there are this critical compliance issues that you need to consider as well as a result of this. Now, there were essentially two cases. I'm not going to go into the details of those cases. We would have material prepared for this, but the first of which was in 2020. Well, it happened in 2022. The case basically reviewed and revised the sentencing principles for breach of the employer's duty to take reasonably practicable measures to ensure safety and health of the employees. Right. This is a case that where the accused company engaged in installation of industrial machinery and equipment and mechanical engineering works with building construction as a secondary activities, and it supplied a tower crane, right? And then the victim was struck by the suspended tower crane, part of the tower crane at the shipyard. The assistant field manager at the time was aware of the rigging and all of that, and the victim's death was directly caused by the company's failure to ensure adequate implementation of its safety workplace procedures for the erection of the tower, failure to establish and implement an adequate lifting plan, failure to do all of these things resulted in it. And so when the case was being analyzed, the issues that the court had to determine was whether to adopt the prosecution's process of alternate sentencing if it was need to be. But basically what happened is that the court looked at it and says there was a breach of duty to take necessary practicable measures, right? The judge, in determining and assessing the level of harm, the level of culpability of the accused party, found that there was negligently failing to implement safe procedures and lift planning. So the court found that there was these kind of breaches substantially taking place, and eventually the court imposed a fine of 220,000. Okay, so there wasn't a jail term, but the imposition of the fine was high, right? In another case, it was a 2020 case against an individual. The individual was actually held the position of the workplace safety and health officer. And the court found that he was responsible for failing to do certain things. And basically what they did at the end of the day was he was fined. In assessing, they also looked at the categories under which he should be, whether the level was high or low. And they found that on the issue about culpability of this person, what the court said was this: as the breaches committed by the accused were not duties imposed on him directly, and as his role was to ensure that these requirements were met or to advise the occupier of them, his culpability could be assessed to be within a low and medium category. So the fine that was imposed on him was lower. So essentially what all of these things, all of these cases do is they tell you that they have now set a clear guideline as to how the penalties should be imposed. So it's similar to some things our speakers in the panel have discussed, highlighting the court will look at who is the party, what was the level of responsibility, how bad was the injury, and so on and so forth, right? And then decide on how to impose, whether or not you would impose a more severe penalty or not. All right, and that's essentially it. I think it's also important. We were just reached on the hour. This session, I just want to highlight before I ask everybody else for any last comments, is that one, that these sessions are recorded, and so participants who are interested in it can get access to it. The slides would be made available as well. Especially this week's, we have the slides from Korea. From Singapore, we would also put together a number of slides because we have similar provisions as I described now. So in conclusion, I'd like to leave the last 2 words or a couple of words to our Korean team, but we start backwards from Vishal. Anything you'd like to add to this?
We good for this. We good. Yes. Thank you.
Okay, Vana, I know I'm putting you in the hot spot, but from Cambodia, do you have anything else to add?
No, Anil. I think we shall cover pretty much all of it.
Yeah.
So hopefully during our post, we can share more on the regulations and law related to constructions.
Perfect. Okay, that's in 2 weeks' time when we come across to Vietnam and Cambodia. Cambodia's got a part covered. Hung from Vietnam.
I have no further comment.
All right, thank you. Then Adi from Indonesia.
Yep, nothing else.
Thank you. And so over to Jason and Tim for the last couple of words.
So thank you, everyone. Just one point, I think one of the attendees on the call, Gareth, he texted just to highlight, maybe it wasn't clear, the Occupational Safety Act and SAPA sort of work hand in hand. It's not as if they separated. So it's just a case of SAPA encompassing that plus more. So it's the add-on is the accessibility to the CEOs at the top, and I think that's the critical part. So thanks for that feedback if that wasn't clear from the presentation.
Oh, thank you for that, Tim. Jason.
I'm good. I've got no further comment.
Right. So I'd like to thank all my panelists. Thank you so much for joining us today and delivering this from Korea. We take a break next week, and the week after we come back to Indonesia, and then Indonesia will have an exciting session. We just had a brief discussion about that, right? And it is also interesting just to conclude that almost every week we have different aspects of the construction industry that are being tackled by each of our jurisdictions, and that's exciting. All right, and please do join us if you can. Please do put out the word to everyone else, and thank you so much for joining us.